Welcome to this edition of PPSA's Protect Privacy Now podcast. Hello there, I'm Mark Udall. I had the great privilege of representing the state of Colorado in the U.S. Senate and before that in the U.S. House. And I ended up serving on the Senate Select Committee on Intelligence, where I became aware of the extent of the potential for inappropriate, that is another way to put it, warrantless surveillance of the Americans by our federal government. And I have with me today Patrick Toomey and Ashley Gorski, both of the American Civil Liberties Union. Patrick's the deputy director of the ACLU National Security Project, and Ashley is the staff attorney at the ACLU's National Security Project. Ashley and Patrick, thanks for joining me today. You're both on the front line using Freedom of Information Act requests and lawsuits to try and pry out the details of how our government watches us and reads our communications. As I've said, I'm really pleased to have you here today and look forward to discussing with you the surveillance of us, of the American people, by the federal government, how it works and what we know and what we don't know, and what Congress should do about it moving forward. If we can, let's begin with the Foreign Intelligence Surveillance Act, or as we fondly know it, by FISA, and specifically an authority in FISA called Section 702, which has to be reauthorized by the Congress by the end of December, or it expires. And I think I'll kick this to Ashley first. Would you explain to listeners what FISA is and why Congress added Section 702 to it in 2008? In short, would you let us know how this program is supposed to work?
Of course, and thanks to PPSA for having us on the podcast today. So I'll try to keep this short. It is a long and complicated story, but the short version is that in 1978, Congress passed the Foreign Intelligence Surveillance Act, or FISA. And this law was a response to a landmark investigation by a legislative committee chaired by Senator Frank Church concerning decades of executive branch surveillance abuses against the American public. So through FISA, Congress sought to rein in foreign intelligence surveillance by the executive branch. It created a secret court called the Foreign Intelligence Surveillance Court and said that when the executive branch wants to conduct electronic surveillance in the US, it needs to go to this court and show to the judge that it has probable cause to believe that the target of the surveillance is a foreign power or an agent of a foreign power. So the showing is different from a traditional warrant requirement in a criminal investigation, but there are some similarities because the executive branch has to make a showing to a judge about the specific surveillance and the target of its surveillance. And this was the regime that was in place basically until 9/11. And then in the wake of those attacks, the Bush administration conducted a warrantless wiretapping program with several components that violated the Fourth Amendment and violated FISA. And after media reporting on that program, after some public outcry, the Bush administration sought to bring parts of that program under judicial supervision, under the supervision of the secret FISA court. And it did that with parts of the program, but when it came to the warrantless surveillance of the content of Americans' international communications, there wasn't a provision of FISA that it could try to shoehorn that surveillance into, because the surveillance was just not permitted by FISA, because the Bush administration was conducting it without going to the FISA court and without making that individualized showing. So the administration went to Congress and sought authority to conduct the warrantless surveillance of Americans' international communications. And Congress granted the administration that authority in 2007, and then in 2008 in what became Section 702 of FISA. And that's the very controversial topic for today's conversation. So that law allows agency analysts to conduct fully warrantless surveillance with no FISA court approval of individual targets if the target is a non-US person abroad and the purpose of the collection is to obtain foreign intelligence information. And one of the problems here is that foreign intelligence information is defined very broadly to include even information about the foreign affairs of the United States. So the targets don't have to be suspected of any wrongdoing. They certainly don't have to have ties to terrorism. They can be journalists, human rights workers, any non-US person abroad who may be communicating about the foreign affairs of the United States. And we know that the scope of the number of targets under the law has steadily increased over time. In 2021, the government reported that there were more than 230,000 individuals and groups targeted under the law. Because that number includes groups, the impact of the actual targeting may be even broader. So this surveillance, which happens without a warrant, sweeps in Americans' communications with those foreign targets. Those are communications in which Americans have a reasonable expectation of privacy. And based on the data we do have, in all likelihood, the government is collecting more than 1 billion communications each year under the law. So the FISA court's role is reduced to overseeing on an annual basis the general procedures that apply to this surveillance. It is no longer approving individual targets when the targets are non-US persons located abroad and the surveillance is conducted on US soil or with the compelled assistance of US companies. The traditional FISA regime is still in place when the government wants to target an American, for example, like Carter Page. Many people listening today are likely familiar with the abuses, the errors and omissions in the applications to the FISA court to surveil Carter Page. The surveillance of Carter Page was different because that involved traditional FISA, but still goes to show that the secrecy that surrounds the FISA regime is enormously problematic for Americans' rights.
Thanks, Ashley, for that overview. I'm going to kick it to Patrick now. There are a lot. I was going to say a lot. I think there are a lot of allegations that Section 702 is being used for massive domestic surveillance. Patrick, would you share with us why you think those allegations have real merit and substance?
Absolutely, Mark, and thanks for having us on. I think the short version is that the FBI is increasingly using Section 702 as a domestic spying tool, which is completely at odds with what Congress intended when it passed Section 702. And you may know that as well as anyone, as a representative, as a senator, what Congress had in mind when it passed this statute. But what we've seen through disclosures to the press and through transparency reporting over the past few years, and since the last time Congress reauthorized this law, is that the number of times that FBI agents are sifting through this pool of data that's swept up under Section 702 in the way that Ashley described, the number of those queries that are directed not at foreigners overseas, who the government said, were originally the targets and then are nominally the targets of the surveillance. Instead, these queries are looking for the emails and the text messages and other communications of Americans who are swept up in that net that captures so many foreigners, but also implicates the communications of Americans who are on the other end. Someone who calls their family member who's overseas, or a business colleague overseas, or family and friends overseas. So there are a lot of ways that Americans can be swept up in this. And although the FBI and the NSA and the CIA are prohibited from targeting Americans on the front end of that surveillance, they aren't prohibited from turning around once the communications are collected, millions and millions of communications each year, and looking through the pool of data that's been amassed to see, we have a tip and we want to investigate an American, and we're going to search through all that data to get access to private communications that are in the FBI's databases.
You mentioned what did Congress intend, and I think the majority of Congress intended to use this to surveil overseas actors who might have malign intentions towards the United States. I don't think many members of Congress conceived of it being used in the ways that we're pretty clear that it is now Section 702 is being applied. Ashley, in that vein, can you talk about what the so-called backdoor loophole and how it's being used?
Sure, I'm on mute. I can send it back to Patrick to kind of elaborate on this set of questions, but it has to do with the FBI going back through its Section 702 databases to deliberately look for Americans' communications without getting a warrant. And of course, these communications were acquired without a warrant in the first instance. So it's really a end run around our Fourth Amendment rights.
I heard the number of over 3.5 million searches. How do we know that? And did you want to expound at all on that? I mean, you both talked about it, but that's not insignificant, quite frankly.
Yeah. Yeah. I mean, just to put a point on the backdoor search kind of concept for everyone, if you think about, the Constitution protects Americans' privacy in their communications, their property, and the Fourth Amendment creates what you could call a front door. If the FBI or another government, law enforcement or foreign intelligence agency wants to get access to Americans' communications, they're supposed to go through the front door, which means they go to a judge with probable cause, the way that Ashley described, and they apply for a warrant. And the judge looks at that individualized application and says yes or no. But these searches, these queries the FBI is conducting are going through the back door because they don't go to a judge. They aren't showing probable cause. Instead, they've swept up all these communications under the guise of targeting foreigners. And then they're turning around and saying, well, actually, we're interested in the Americans whose communications we've collected. And we want to sift through those. We want to query them, for people's names or email addresses and see what kind of private communications they've been engaged in. And the number is huge, like you said. In the last transparency report that the Office of the Director of National Intelligence released, the FBI acknowledged that it was engaged in up to 3.4 million of these queries implicating Americans in a single year. And it caveated that number in a couple different ways. And we can turn to some of those caveats. But even if you discount that number, significantly, even if you cut it in half, or even if you, said it was an order of magnitude too large, you'd still have thousands and thousands of these queries happening. And that should trouble members of Congress and should trouble Americans, because that's a way in which the FBI is relying on these warrantless searches to advance not just the foreign intelligence investigations that were kind of front and center in Congress's mind, but all manner of domestic investigations focused on Americans.
I might, if I can interrupt or interject, that the report of the 3.5 million searches comes from the Wall Street Journal, which is a pretty reputable newspaper with investigative journalists who are generally highly acclaimed. Another report was that a member of Congress had been surveilled under 702 or under the authorities that the FBI thinks it has. Do you know if other members of Congress have been the subject of searches?
I don't think we know the full picture of who's been swept up in these searches. I don't know of any other examples of members of Congress, but in just this tiny sliver of examples that we've learned about through the type of compliance reporting that you just described, through some of the FISA court's opinions that have been disclosed, they really run a whole range of very problematic scenarios, including community organizations that are coming to visit the FBI, their agents running searches on those types of individuals, contractors who are coming to do repairs at FBI offices, domestic investigations related to things as kind of run-of-the-mill as healthcare fraud, or things that have nothing to do that's to say with national security or foreign intelligence gathering.
Ashley, do you want to add any comment there?
No, we'll just underscore the points that I think both of you have made, that when Congress enacted Section 702, it was thinking of it as a tool to acquire foreign intelligence, and for most people, a specific kind of foreign intelligence related to terrorist attacks. And because of these backdoor searches, the FBI has essentially repurposed this tool into a surveillance tool to address ordinary crime.
Yeah, I was looking at my list here. I actually have to study it to get share the long list of reporting that includes the FBI investigating current and former U.S. government officials, journalists and political commentators, business, religious, and community leaders who applied to participate in the FBI's Citizens Academy. And there was even a report that an agent's colleagues and relatives, that is, an FBI agent's relatives and colleagues, has been surveilled. And I think it's a rhetorical question, but I have to ask it. I mean, what do these actions have to do with the 702 authority from foreign intelligence? I think you both just answered the question. They don't, and that's why we, the three of us, and many other people, increasingly share real concerns about what's going on. It also, through PPSA's work, it's been heartening to me because you have right, left, and center leaders and concerned citizens saying, "Hey, this is important to all of us, wherever you land on the political spectrum." And when we conclude, I want to bring us back to the Fourth Amendment and your all's beliefs and insights into what the Fourth Amendment means. But in sum, would you agree that the FBI is using a foreign intelligence surveillance statute to surveil on the domestic front American citizens? It's that straightforward. Would you agree?
Absolutely. I mean, there are really at least two dimensions to the problem that we see coming through in reports like these. One, the FBI can't even follow its own rules. Time and time again, it's shown through reports like these, scathing FISA court opinions about its lack of compliance, that it's not following even the basic rules that the FISA court and Congress have imposed. The second problem is that the rules themselves are too permissive. And that's what this 3.4 million number is showing us. The threshold for conducting these searches of Americans is so low that agents are engaging in them on a routine basis. And in that way are engaged in millions of warrantless searches of Americans' communications every year. And both those problems are ones that Congress urgently needs to address.
I'm tempted to, we'll jump ahead to the Supreme Court, but let me first add, I think as it's important here, ask about the reauthorization process of 702 and what each of you'd like to see in a reauthorized Section 702, and maybe comment on whether we even need to have a reauthorization. But yeah, why not, Ashley, why don't you kick it off, and then we'll go to Patrick.
Sure. I think the Section 702 reforms that we want to see fall into three primary buckets. And the first has to do with the scope of collection at the outset. So as I mentioned, under this authority, the targeting standard is very low, which means that the number of targets is very high, and it gives the government the discretion to enlarge that number of targets at any time. So a primary area for reform would be to rein in the scope of the surveillance by limiting targets to those where an agency analyst has reasonable suspicion that the target is a foreign power or an agent of a foreign power, as opposed to any non-US person abroad who might be communicating foreign intelligence information. In addition, Congress should rein in that definition of foreign intelligence information so that it doesn't encompass, for example, any information related to the foreign affairs of the United States. Congress could definitely make the scope of the surveillance narrower at the front end. And then the second set of reforms has to do with how the government is using and searching through these communications once it acquires them. And here, the most important reform is to close the backdoor search loophole. I think that those backdoor searches for Americans' communications are the most problematic part of the surveillance. And we lost Mark, but now Mark's back. Hey, hi, Mark. I was just saying that the backdoor searches are perhaps the most problematic part of all of Section 702. And Congress should require that if the FBI is going to be looking through its Section 702 databases for the communications or data of Americans. It needs to get a warrant or court order to do so. And then the third bucket of reforms has to do with oversight and accountability. And here there are a number of problems and issues, but the reforms are straightforward. So the first is that the fisc amici, so the secret court, the Foreign Intelligence Surveillance Court, has these one-sided proceedings. And in recent years, Congress created a process for the fisc to appoint amici in novel or significant cases, and that is a positive development. The problem is that the amici still don't have access to all of the information that they need to do their jobs well. There are a lot of issues related to the fact that these materials are classified. So the FISC need to have full access to all of the materials that they need to do their job. And then secondly, they need to be appointed in a broader set of cases. So this issue goes beyond the Section 702 surveillance and also to the traditional FISA surveillance, where there are a lot of novel cases or cases involving sensitive investigative matters where the court would benefit from having that outside perspective. And it's not getting it because the judges are not appointing the amici in all of these important cases. So reforms to strengthen the fisc amici. In addition, there are real issues with oversight and accountability in the ordinary public courts. And that's because when criminal defendants are prosecuted where the government uses evidence that was obtained or derived from Section 702 surveillance, those criminal defendants historically, and we have concerns about the present day as well, historically, they did not always get notice of the fact that they were subject to this very controversial surveillance. It's a long story, but basically they were getting notice for a while. The notices have dried up, and we have reason to believe that the government is relying on an unduly narrow interpretation of its notice obligation. So Congress needs to make very clear that if the government is prosecuting an individual using evidence that was obtained or derived from Section 702, notice has to be provided, and the government can't get around that obligation by engaging in a practice known as parallel construction, where it recreates the trail of evidence using a less controversial form of surveillance. In addition, there are real issues with disclosure to defendants and defendants not getting the information that they need about the surveillance to bring a meaningfully informed motion to suppress, which again makes accountability so much harder after the surveillance has concluded. And then finally, for civil litigants who want to challenge this surveillance, Congress needs to reform a privilege known as the state secrets privilege, which has been used to preclude meritorious civil litigation concerning Section 702 and other forms of foreign intelligence surveillance. And with that, I should turn it over to Patrick. You may have additional questions about that, Mark, that I know Patrick's happy to talk about.
Patrick, I know the Supreme Court declined to take up a state secrets case, and if it fits, maybe talk about that, but also feel free to add your thoughts on 702 reauthorization.
Absolutely. I mean, like you said, Mark, last week, the Supreme Court denied cert in one of the cases Ashley and I and the ACLU and the Knight Institute have worked on for many years, which challenged a form of surveillance called upstream surveillance that the NSA conducts under Section 702. And in short, upstream surveillance involves the continuous monitoring of internet traffic entering and leaving the United States. So as our emails or web communications flow in and out of the country, the NSA has devices set up at those major choke points that scan communications in a way the founders never could have imagined, and certainly in a way that isn't consistent with the warrant requirement that we've talked about today. And so we challenged that surveillance in the years after the Snowden revelations. And went up and down in the courts for many years before the case was dismissed after the Fourth Circuit Court of Appeals. One of the judges ruled that the state secrets privilege didn't allow the case to proceed. And, I'll say a little bit more about what the state secrets privilege is, but one of the big takeaways from the Supreme Court's decision not to take up the case and hear it is that it makes the types of reforms that Ashley was mentioning as part of this reauthorization process even more important. And the hurdle that we encountered in the case was that Wikimedia, our client in the case, had put forward really extensive evidence based on the government's own disclosures, alongside expert analysis by a technologist explaining that it was subject to upstream surveillance. Wikimedia engages in more than 1 trillion of these international communications a year, and it was able to show that some of those communications were subject to upstream surveillance. But when it sought to, make that showing in the courts, the government came back and said, well, we might have a secret defense that we would put forward if it wasn't, in the government's view, so secret. We might rely on secret evidence to contest some of Wikimedia's claims. And the government said, we don't want to put forward that secret evidence in court. And therefore, we believe the case should be dismissed based on the state secrets privilege. Now, that's not historically how the state secrets privilege has worked. The way that it's usually worked is the government says, we don't think this specific piece of evidence can come in because it's too sensitive. But the courts then say, okay, we'll carve out that secret piece of information based on the government's national security assertions of sensitivity. But the case will go forward independent of that sensitive evidence. And that's not what happened here. Wikimedia had all this public evidence. It was ready to go forward. And it was only the government that said it needed the secret information, and that alone was enough for dismissal. And there's a circuit split in the courts around how to deal with situations where the government says it wants to rely on secret information for a defense. And we pointed out that split to the Supreme Court as one of the reasons the Supreme Court urgently needed to intervene and take the case to resolve that difference of views. So we're disappointed, of course, that the Supreme Court didn't take the case. But come back to your question to Ashley and to both of us. There's a lot Congress can do here to address these problems, and that's what we think needs to happen now. It's clear that the courts are not hearing these challenges. They're not playing their traditional role under the Constitution of ensuring accountability when the executive branch has engaged in really serious exercises of its power to infringe on the rights of Americans. And Congress needs to put in place procedures that are clear, that both protect sensitive information where necessary, but also allow the courts to get to the merits of these cases, to say, this surveillance violates the Fourth Amendment, and these additional safeguards are necessary to protect Americans' privacy.
Yeah, from one point of view, what you all do is so important, and it's in an arcane area of the law, but it shouldn't be arcane. It's fundamental to our basic liberties. With the state secrets decisions or non-decisions, I'm reminded of sovereign immunity, where the king can go do no wrong. And we don't have a king per se, but some ways that seems to me the federal government is acting with kingly powers. And I think I answered my own question. I think I'm being a little mischievous about letting 702 expire, but I think you'd have a Wild West situation perhaps. So I think the best path forward, and you could comment briefly, I think, is to reauthorize, but with the kind of conditions that you all have laid out, and hopefully with the leadership of people like Senator Wyden and others who really understand this and have long been on the front lines. So I don't miss some aspects of serving in the Congress, but I do miss serving with Senator Wyden and really working on this important area. And maybe we can conclude. I know we could talk for quite a long time here, but for me, when I became more and more immersed in the Fourth Amendment, which is not as well known of the Bill of Rights, it became apparent to me that privacy is key to all our other freedoms. And so I became more and more passionate about standing up and saying that this can't proceed. We've got to shine a light on this. We have to rein in this, in many cases, well-intentioned effort to keep us secure. But we quote Jefferson and Franklin and Washington all the time, and I'm gonna paraphrase one of them. I think it was Franklin who said, in effect, "Look, if we value security over liberty, we deserve neither." And free society, there are some risks involved in people, and so for me, the risks are generally well worth taking, if you will, to maintain people's privacy and to limit particularly domestic surveillance. But if either of you, both of you, just comment briefly on the Fourth Amendment and the importance of it. And I think that's a good way to conclude our session. Ashley, you want to kick it off?
Yeah, I think that's a very elegant way of putting it, as privacy is a freedom on which so many other freedoms depend. I mean, it's absolutely foundational, and the government's surveillance apparatus and its slow undermining, or it's necessarily slow, its longstanding undermining of those Fourth Amendment freedoms, I think is absolutely corrosive to us as a society. And I know with the Wikimedia litigation in particular, the chilling effects on users were significant. And I think we all have to be concerned about how we are self-censoring our own speech, and how others may be self-censoring in response to government surveillance, and what the long-term implications are for a robust, diverse, democratic republic.
Yeah, I think that's exactly right. I mean, privacy is so essential to all of us being the person, that we want to be, to protecting kind of a sphere of personal autonomy and our ability to think and speak freely with others. And the Fourth Amendment has, interposed for generations and centuries a barrier that, the government can't cross without satisfying certain fundamental conditions. And some of these technologies that are being used today really, really are eroding those barriers. And we need Congress to come up with safeguards that continue to protect those zones of personal autonomy and freedom and ability to speak and associate freely. And we need the courts to be there right alongside us, making sure that the government, the executive branch, like you said, is held to account when it tries to cross those lines without meeting those basic constitutional conditions.
That's beautifully said by both of you. I was thinking too that back in the day, and we romanticized the revolution, and in some ways that's well deserved and appropriate. Other times we have to leaven that a little bit. But you think about it, back in the day, the king could take your property, your money, could take your life even, but maybe most valuable, your freedoms. And certainly the founders were willing to put their lives on the line to create this form of self-government. But in the process of moving through the 1780s and the Articles of Confederation and the situation we had there, the fact that this is the Fourth Amendment, I think speaks enormous volumes. And so I just want to commend you all for the really important work you're doing. And maybe we can have a follow-up. I know we could talk for quite a while, but you're doing really important work. So thank you for, in some cases, I'm sure it's thankless, and you get all the way to the Supreme Court and they say, no, we don't want to hear what you have to say, but I bet you're going back to the court. I bet you've got some additional strategies and plans to keep this right in front of the key folks. But let's spread the word about Congress and the important opportunity they have here to protect our privacy, which wherever you are on the political spectrum as an American, I think we would all support it. So thanks again. Let's do it again sometime.
Thank you. And thank you for your longstanding support and advocacy on these issues as well.
Well, you call on me anytime. I'm ready to weigh in, be on the, well, you're on the front line, so I'm certainly ready to lend my voice and my passion and whatever else I have left to the cause. So you take care.
Awesome. Thanks so much, Mark.